Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And, oh my goodness, it is good to be here. It is good to be here. You know, I don't know if you guys know this. You probably do. You probably do. Children are wonderful, but they are also wonderful incubators of disease and illness and all sorts of pestilence. They're walking petri dishes, creating new world-ending viruses constantly. And it's lovely when they just go anywhere where there are other monstrous little incubation biological weapons running around trying to get everybody killed. But I'll say it this way, only 2 of my 5 are sick, which means only 3 to go. That's how this tends to play out. All right, on the agenda today, we've got a couple things to do. In just a little bit, I will start off addressing a complaint. Something I don't do on videos very often. Hold on. But when they annoy me enough, and not when the person annoys me enough, but when the complaint annoys me enough, that and it's difficult to do this on an actual, like, just by text, because I do try to address some of these things via text on in the comments or on Twitter or whatever, and sometimes it just doesn't work, and there are a couple reasons for it, and some of the reasons might be that the person on the other end is being obstinate and not talking in good faith and assumes that I'm not talking in good faith too. I don't know. I'll let you guys see it. We're going to go through the conversation I was having with this person, and then I'm going to show them what I have available as a tool, because this is one of the stupidest complaints I can get. And it's infuriating. It's infuriating because there's literally no reason for me to do it. Okay? So the complaint, in summary, is that I deleted some jackhole's critical comments about my MXR live stream. All right? And then same guy got super mad about the short Judge Chubb video I did. Here's the thing. I don't delete comments. I barely have time to read any of the comments. If I read a comment, it is a function of a couple things, all right? In my phone's YouTube Creator Studio app, there is a thing that gives me the 3 most recent comments on any videos at all. So when I open my app, I might see a comment. If the comment is interesting, not interesting, if the comment allows me to provide a response that I think will be helpful, I'll do it if I have time. Right? If it's a criticism, a lot of times I'll try and address it or ask for more information or whatever. The other times I see comments are when YouTube notifies me, and that's usually when I've replied and then I get a reply back to that. YouTube will sometimes send me a notification. But here's the deal. I don't have time to go over every single comment left on every video. I hope you guys understand that. It's not personal. I do try and flip through them from time to time, but if you get a response, it's likely just a product of timing, not time, timing. Time and timing, maybe. But I happen to see it. I happen to have a few minutes to respond or whatever. This one, I did try to respond to. Now, of course, it opened with insults, so I respond with a mild insult. That's how it goes sometimes. And then it kept going, and I kept getting notifications. So I went back and responded to it. You'll see all this. You'll see all this. But here's the thing. Post all the negative comments you want. I don't care. Like, what? Like, why would I be mad if you disagree with me? Why at all would I be mad if you disagree with me in comments? And here's the weirdest thing. If I engage you in comments in which you're critical of me deleting comments, and I say, why would I, like, there's no reason for me to do that. And you're like, well, there would be. And like, if I deleted comments that were critical, I'd just delete this comment instead of responding to it. So it doesn't make any sense. It doesn't make any sense to me. Maybe you guys will see the grand plan. But then here's the other thing. Here's the other part of this that I'm going to show you. YouTube auto flags comments for what YouTube calls spam. And the other section is held for review. I don't have anything to do with it. I would turn them off if I could. I don't think I can. Maybe I'm dumb. I get that you don't think your comment is spam. Guess what? I don't think your comment is spam. YouTube thinks your comment is spam. And if you ask me why YouTube would think that your very well thought out, super witty, awesome, massively critical, super cool guy comment is spam, fucking ask YouTube. I don't know, dumbass. I can't possibly know. It's YouTube's thing. But I will go ahead today and show you what's in there for this specific guy. Exactly what it says. I think in my held for spam folder, there's like 2,000 comments. And in held for review, there's like 1,500 comments. Something like that. I might have the numbers switched or whatever. It's something like that. I don't know. I don't go through them. The interface to go through them is slow. It's clunky. It's bad. You can't just approve them all. I don't think, because YouTube will flip out if you approve like the rape comments. So it's nuts. It's nuts. Long story short, I don't set anything up for YouTube to do this. YouTube just does it. Nothing I can do about it. And no, if you think I went and singled out your awesome comment to delete it, absolutely not. I don't care if you say something negative. Please do. Here's the other thing. It's actually better to leave up negative comments and have negative interactions than it is to have less comments. YouTube's algorithm works this way. Interaction is good. Videos that get downvoted into oblivion, YouTube actually gives credit to the, the creator for that. It's a positive thing for the creator to get negative ratioed, to get negative comments. Interactivity is good. YouTube says, ooh, controversy. People want to participate. This is neat. We like this. This sells ads. Of course it sells ads. And YouTube currently isn't claiming to be held accountable for the comments. You know, they may claim some accountability. So they have their code of conduct for creators. But YouTube has a lot more leeway in the comments, so they don't care if it's got just a bunch of F-bombs in it as much as they would in a video. They're not going to cancel advertising for the comment. And their word filter is going to pick it up and put it in held for review anyway. There's literally no reason for me to do it. All of the benefits and positives are for me to leave up positive and negative comments. I don't know. This is YouTube 101. You're going to get a course on YouTube tonight, I guess. So I don't know. This stuff is so infuriating. Like, you know my weakness. Here it is. You know my weakness. If you attack my integrity, then I respond more often than I need to. Because I don't owe anyone a response to anything. I know I got it. But I do actually care a little bit about my integrity, and my integrity is that I leave this stuff up. Because I will take the criticism. And a lot of times I actually take the criticism. This is an evolving thing. And I am always trying to deliver a better product and an interesting product to you guys. I'm a capitalist. That's what I do. So there are some super chats I want to go through. I'm going to get this set up. And here's the best part. I'm going to do this, and you know I'm going to boomer it. I'm gonna like be hacked tomorrow by something I show on the screen today. So you can laugh at me when that happens too. But there is, we'll start with this very large super chat. And I do hope you meant it. But if you didn't, make sure you contact YouTube right away. I have nothing to do with that if it was a slip of the finger. But if it wasn't, super huge thank you. And thank you either way to Drayfon with a massive, massive contribution. Says, I have a complaint for you, Nick. And that is you don't take enough of my money. Oh, and try a game called Kenshi. Kenshi. I've seen that on Steam. Let me ping it real quick and see if... I think it was on Steam. Kenshi? Yeah, here it is. Is this like the, yeah, this is the squad-based RPG thing. Is this good? I'll look it up. I'll buy it right now. I don't even care. I don't even care. Here, we're going to buy it. Kenshi is being purchased. I'll give it a look-see. Maybe it'll be fun. Yeah, I agree to the terms of service. Oh my God, sell me the damn game. There we go. Kenshi is on. So thank you very much to Drayfon. that was unexpected, but always welcome. And yes, I will check out Kenshi. Pooh Zerker says, hypothetically, RE plaintiff's attorney, endless money. Who and how would you sue for damages caused by Corona-chan, assuming damages in proper jurisdiction? So you have infinite money. Well, depends on the, I guess depends on the transmitter of the disease. Typically, you would have to get the disease. You'd have to suffer some sort of damage for it, and you'd have to get the disease due to negligence. So if there was someone who was out there who's exposed to coronavirus, had knowledge of it, and was negligently or willfully exposing themselves to others, that could be the foundation of a suit. You'd want to go after someone massive. Or the really bad case, I think, would be, and hope to God this doesn't happen. I would actually cry like mundane mad if this did happen, I think. If a daycare worker was knowingly exposed to coronavirus, went, infected a bunch of kids, and they died, that daycare chain would get absolutely reamed by the parents. That is actually what I think would be. That's the type of case that would get out there, and that would have a strong chance. Because all of these places are going to be getting notices. They're going to have practices implemented, and if they don't implement proper controls on their employees or properly inform them, or the employee gets it and negligently ignores it or willfully ignores it, you've got issues there. But or if the workplace, this would be even worse. If the employee says, hey, I was just at a thing, I've got to take the day off. I've got a woo cough, and I was just at the best Chinese restaurant eating some oysters or something, and I got a what I think is a woo cough. I need to stay home, and it's one of these places like KinderCare or something, which is just a mill churning out poor daycare workers. And those daycare workers were told, look, if you don't get in here, your job's on the line because you're short-staffed. It's like an entry-level sort of position, and then something happens. That's when the liability goes on to the daycare for negligently supervising their employees and for allowing the potential transmission of a highly communicable disease to go through bad practices, right? That's the plaintiff case that you'll probably see. Other than that, it's going to be really hard to peg a plaintiff's case onto coronavirus, just because of the nature of how viruses spread. And it's usually, there's not a duty to avoid people. As weird as that sounds, there is when you're put in trust over a particularly vulnerable population. Same thing could happen at an old folks home, but due to how they calculate out damages, it'd be worse to kill a bunch of kids than to kill a bunch of old people who are already dying. And I know that sounds terrible, but that's the cold logic of the value, the potential value of life, right? Someone at the end of their life who's retired and in a home probably isn't going to be making a bunch of money, so the pecuniary loss is lower. All right. So there is that. Mithrin Emra says, of course you delete comments, Rackets. We all know how thin-skinned you are. I mean, it isn't like YouTube has a history of sending comments into oblivion or anything like that. And if you go back into the lore of this channel, I was accused of this before by, I think, Tito, back during the Maddox saga. I was accused of this before, and it turned out that the person didn't have their settings of newest, first, or top comments or whatever. They didn't have their settings right. So their comment was actually there. They just didn't see it because YouTube didn't show them because it wasn't a top comment. Next. Intimidator0108 says, holy poop, Nick, you're actually on time for once. Are you actually all right? I am all right. Lol. Also, I'm glad to hear that you found the clip I sent you on Twitter from one of my Call of Duty Modern Warfare gameplays. Here's 20 to tick off Moron and Marky. That was a great clip, man. He's playing Call of Duty and he's about to snipe a guy, and the guy gets airstriked and just catapulted into the ether. That was good. Rick Robinson says, late and gendered, but here you go to sing. I'm sure you know the cadence. Come on. He wants me to sing Judge Chup Lost to the tune of Maddox Lost. Texas is the winner. Not today. Not today, my friend. But we'll see. You know what would be funny? If Judge Chup ends up losing his district court seat in that election. Oh, man. Oh, God. Verticon says, hey, I sent a tweet to you. It's a link to a GoFundMe. One of my good friends I played video games with for years had a stroke. He's now a father and is a long road to recovery. Could you please link it to the chat, please? I can. I, of course, cannot... Let's see. Oh, goodness. Where is it? It was, I gotta find that specific tweet. What is it? Okay. Where is it? I don't know. Which one is it? I don't know your Twitter name. Let's see. Okay, a Verticon. Can you send it to me again or ping me on Twitter? Send it just send me another message on Twitter and I will, so I know which your Twitter handle is. Because I don't know which one is yours. I think it might be this one. I don't know. Sorry, buddy. Just hit me back on that and I'll try and find it. Okay, next. Finally, Pooh Zerker says, damn proper attorney answers re negligence. One more question. Do you know of any case law concerning suing the U.S. government, knowing it's forbidden in the Constitution, but how would you do it? P.S. Best show and chat on YouTube. I do agree on the best chat part. Best show is up to you guys. I'm biased on that one for sure. You tend to have to sue a particular government employee in their official capacity. You can sue the U.S. government. I believe there are suits out there. The government can accept the suit. They can accept being sued rather than invoking immunity. So it is possible. I'm pretty sure there are some cases out there on it. I don't know of any off the top of my head, but maybe a short video on that at some point. Would be interesting. You know, it's always one of those things. Oh, there we go. Oh, you sent an actual tweet. Okay, here we go. Yes. So here's the link. You guys can check this link out and see if you want to help this guy out. That is up to you. If my mods could go ahead and share that for me, I'd appreciate that as well. And then we have Siren Jag says, does this guy have brain covfefe virus? My God. Plus, why does this guy get your cray-cray responses when I've been lovingly posting all of my insults of varying quality to Twitter for the past 11 days? Are you insult cucking me, Nick? Yes, that's what I'm doing. But I think you're only an insult cuck if you like it. So. All right. After we do the deleted comments portion of the chat, we're going to briefly talk about what's going on in Vic's case. Monica and Ron have filed. They filed actually on the 6th, which I believe was that Friday. It's Thursday or Friday. I don't remember what day was what. Just a moment. March 6th was Friday. They did file on Friday for their extension. It looked like they might have forgotten to file for the extension for their response, which would have been due today, but they did end up filing that. Lemoyne made a tweet yesterday, and he thinks that I'm going to freak out over the fact that they haven't paid their motion fee. But I don't freak out over stuff like that because the court gave them until like the 18th to pay their motion fee. So I don't know what his deal is or why he thought I would make a big deal out of this. I was going to laugh if they didn't file their extension. I was happy to laugh at them for missing the extension or for missing the deadline again, knowing full well that even if they missed the deadline again, they would probably get another chance by the court. Because again, these delays are part of the appeals process and they're just not that big of a deal. I've said that 100 times. So, you know, I don't know. Lungless is, but he's an idiot. So what are we supposed to do about that? All right. Let me set this up. This is going to be an abject disaster. So I'm going to set up 2 windows here. And on the first one, it's going to be me, the comments to this video, this comment thread that we're going to go through. That's going to be the first one. And I don't know if you want to follow along, but it's on the Trump comments here. I don't want the filter. God, what a disaster. This is... Oh my goodness. I'm going to have to like find it. Oh, no. I'm on the wrong video. That's my problem. Brain broke. It's on, not on the Trump video. It's on the Judge Chup video. It's on the Judge Chup video. All right. This is the worst system ever. I can't. Well, I'll show you guys. Here, let's do it this way. Am I doxing anything on screen? I don't think so. Probably. You guys can tell me. So here's the Chup video comments. We're going to go ahead and zoom and enhance. Now, why? Oh my gosh. How obnoxious. We're not going to zoom and enhance, okay? Now watch the scroll speed. Oh, now it's loading more. This is why I don't go through comments on my dashboard. Like, it's loading more. It's great. Super fast, as you can see. A smooth end-to-end user experience. Now, this is... I remember the guy's name. Here we go. Here are the comments. And we're going to go through this. This will take a little time. So I hope you guys are prepared for a little bit of time. Let's see. Because some of these are long. This guy likes to write substantial complaints, I guess. Let's zoom this in just a bit. See, why does it have to zoom in all of my Chrome windows? I get why it would zoom in other tabs, but Chrome windows? Oh my God. All right. Oh, one more thing I need to do real quick. Just a second. So now I need to go to... I need to get the all the comments pulled up to show the held for review and spam things. Okay. Here we go. So you guys can see these sections and how fun these are to navigate. So this is the... I got to shrink this window just a hair. So here you can see published comments, held for review 1.4K, likely spam 2.4K. All right? So, Tillip, I know you hold control on the mouse wheel. It just zooms in and out on every window when you do that. I know. I did that first. It's just zooming in on my other window, which is running the YouTube show right now. So now all of your comments are massive. Okay. So yeah, anyway, so this is where we're going to find Zephyro's comments that he doesn't believe me about. Okay? And yes, someone was right. Find alcohol for this. And since I'm punishing myself, I will drink Gretzky alcohol. Witness you. Everybody will witness you. The comments are... The chat has been enlarged. The chat has been enlarged. But we're dealing with it. All right. Cheers. I found out that this is probably significantly more than a shot, like 1.5 to 2. All right. Here we go. And I hope maybe this is what the guy wanted. Maybe the guy wanted some interaction with me, and if I didn't give it to you somewhere else, I apologize. I do try to interact with viewers as much as I can, but I'm just one man. All right. So he says, look at the cuckery. So this is on my video about Judge Chup losing an election, in which I'm pretty sure I don't claim why Judge Chup lost the election, because you don't really know why someone loses an election. I just laughed at what Chup did for the election. And it's pretty embarrassing that he lost. And we'll get into that. So giddy with excitement to spin the facts to make him appear like there was fault to why he didn't win. If you lose an election, look, it doesn't matter who you are. If you lose an election, it is your fault. It's your fault. You didn't win. You didn't spend enough. You didn't campaign hard enough. You weren't a good candidate. Something caused you to lose the election. And it's you. You're the guy who loses the election. That's it. That's it. There is fault to why Chup didn't win, and that's because Chup didn't do a good job of being a candidate for whatever reason. I still don't believe I said it was Vic's case that caused him to lose. It would be really funny if it was, but I think that's going too far. Anyway, you only attack in the way you did here when you don't have evidence to validate your reasoning. How embarrassing. What reasoning? What reasoning? And what is he talking about? I genuinely don't know what reasoning he's looking for. Chup didn't win the election. Now, I made fun of Chup's judge answer sheet, which is because of, as I said in the video, because of the restrictions put on how judges can campaign, that judge info sheet is like the only chance you really get to campaign, other than going to events and meeting with various people who might say your name to their constituents or put you on a card or something like that. But really, judges are limited in how they can campaign, which I said. So you get this info sheet that people can go request, and they can find equal answers for all of the candidates as to how they answered the question. And judges answer to why he wanted to be an appellate court judge was, I am a district court judge. Literally, that's it. That was his answer. That's a dumb answer. And it, in my opinion, reflects how Judge Chup handles things, which is with the healthiest dose of ADD imaginable. I think he got bored in the middle of answering that very short question. All right. Pooh Zerker says, my name is Rekieta, and I acknowledge the heavenly powers of Lee Man He. Everyone should follow Shincheonji Church of Jesus, the Temple of the Tabernacle of the Testimony. Sorry, not sorry. I don't know what that is, but I commend you for it. I commend you for it. Okay. It's a campaign. Anyone can win. Well, not anyone. Judge Chup can't. The fact people choose someone else over him does not indicate wrongdoing in the case that Ty and Co. utterly effed up at nearly every turn, like you alluded to in the beginning with your I wonder why bit. Now, I don't remember the exact content of the video, so I'm not sure on the I wonder why bit. I don't know. We could find out. I could check this. The beginning on your I wonder why bit. Here we go. Let's review. This is great. Here we go. On March 4th, 2020, Tarrant County, Texas had a primary. Okay, wait a minute. We're going to do it this way. Transcript, Control F, I wonder why. Let's see. So the only there are 3 times in this entire video I say I wonder. Let's go to it. All right, here we go. More points than the other people. No. Oh man. Oh. I wonder what could have caused it. I wonder what types of things might have led up to it. Interestingly, we can kind of take a little bit of a look at that. Okay, we're going to pause it here. This guy is absolutely wrong, okay? He is suggesting that I'm talking about Vic's case as in what could have led up to it. I'm not, pal. I'm about to show you what could have led up to it, and it's his answers. It's the answers he provided in the document that we're going to talk about. Oh my gosh. Oh, the audio is low. Sorry, I'll turn it up for the next. I don't know if there's going to be another clip or anything, but it's literally what Chup did in the campaign. It's... I'm not alluding to Vic's case, pal. I'm not at all. Not having or having past experience as a judge is also irrelevant. Incorrect, my friend. Incorrect. It is quite relevant, especially when you're moving for an appeals court position. Having experience as a lower court judge shows people, it gives people a way to go and actually look at how you might rule on the appeals court. Let's go on. Things like this happen all the time. Look at the various people in the House and Senate as evidence of this. Wrong. The House and Senate elections are vastly different than judgeship elections. And this is a point which, with respect, you have no clue what you're talking about. Not a single damn shred of it. Because judges going for an appeals court position should have some experience with judging. Or with, as the winner did, Brian Walker, arguing in front of the appeals court. But here's the funny thing. Judge Chup is the only person on that card with judge experience at all. And judges often move from district court judges up to federal court judges or appeals court judges or Supreme Court judges in a state or even in the US. And when district court judges are appointed, for example, we actually have a cool example of this. Donald Trump appointed a lawyer to be a district court judge. And he ended up withdrawing his acceptance of the appointment after getting absolutely grilled on the stand by congressmen who were lawyers asking him about his experience. And the fact that he wasn't a trial attorney or a judge played a huge part in his inability to answer their questions correctly or in a way that was satisfactory. Now, would that guy have made a good judge? Maybe, but it plays a big part when you're moving to a higher court to have been a member of a lower court. And that's the point I was trying to make. He's up against 2 other attorneys that are not judges. He had a leg up on them. Also because people can, in theory, they don't, but they can, in theory, actually review the opinions of Judge Chup easier than they can go out and find all of the different filings of the attorneys. And interestingly, when you have someone who is acting ostensibly impartially as a judge, you get to see how they will rule rather than how they will argue when being paid, which is the job of an attorney. So you're just incorrect on this one. I don't know how else to say it. He doesn't kind of emphasize it. He does emphasize it. I probably said he kind of emphasizes his judgeship. Okay. Spinning again, I legitimately am just making fun of Judge Chup. There's no spin involved. He lost the election. I don't have to spin that in any way. He failed at getting elected. Judge Chup absolutely failed at getting elected. And it's great. It's great that he did. Texas dodged all of the bullets with it. Good job, Texas. Good job, Tarrant County. There's no spin necessary for that one. He clearly stated his credentials in his previous statement. Yes, yep. And you can look to his ruling and or past statements on the subject since he has been the judge there for, I believe you said 10 years. This goes directly opposite to what you said in the prior paragraph. So obviously people who care enough to vote on it would know some of his work. Aha! Let me counter that. No, that's not obvious at all. Lots of people who care to vote on judgeships know nothing about their rulings. Because while it is possible to look them up, it's cumbersome. It requires some level of skill or knowledge in researching cases. Plus, most of the people, frankly, aren't trained to know what they're looking at. Example given, lots of people very interested in the Vic case still don't understand that Vic is not the defendant. And they're very interested in it, and they're making business decisions on it. But they don't know that he's not the defendant. And all of the information on Vic's case is readily available all over the place. Chup's stuff is harder to find than Vic's stuff. And people don't know. And they care more than most voters. Lots of voters just go and click a box. Of course, Chup is not going to make a ruling on Vic's current appeal. Even if Chup won the election, he wouldn't be able to take the case. If it was given to him as one of the appellate court judges, he would have to recuse himself because he would be going against his own ruling, and he can't do that. Okay, again, purely opinionated, and I doubt you looked into his case. What? His case? His election? Yes, it is opinionated. And even indirectly confirmed that to likely be the case with your statement. Oh, well, la-dee-da. Let me just go check the exit polling data on Court of Appeals, 2nd District, place 7. Let me just go check the exit poll data on how they picked their appellate court judge. Bro, do you even election at all? Like, do you know anything about elections? There is no commentary on why Judge Chup failed to secure even a fifth of the votes in Tarrant County, in the Tarrant County primary for Republicans. This just isn't a thing that's out there. If you can find it, oh my God, please, I would love to go through it. I would love to read the comments because I've actually read comments from people who did actively campaign against Chup. Whatever that means. I don't know what that means to them, but they can't probably telling their friends, family members, any contacts that they have, oh, that's a bad guy, right? There are people out there who did actively campaign against Chup because of the Vic stuff. So if that was my thesis, which it isn't, I would have more empirical evidence for that thesis than against that thesis based on the comments on my video already. That being said, that's not my thesis. I think Chup lost because 1, no one knows what they're doing when they're electing judges. 2, Judge Chup didn't put forth the effort to win the race. And you can go check it on Ballotopedia, and you can look at his abysmal fundraising, which was, I think, 8 people at $850 a piece. No, 5. 5 individuals at an average of $850 a piece for $4,250 in total fundraising. And he spent like $3,000 on his race. That's it. And that his website's garbage, and his little answer sheet is trash. He didn't try. He didn't put forth the effort to get elected. Like I think it was incompetence. I think he thought he was a shoo-in for it. But that's me. That's me. All right, next. Just because he didn't go with your biased opinion doesn't mean he is wrong and you're right. No, that's not what makes someone wrong or right at all. You are correct there. I think Judge Chup is absolutely incorrect in how he handled Vic's case. I do. Not because of my opinion, but because I think he handled the TCPA improperly. In fact, I don't think he has much experience with TCPAs at all. And I'm hoping to get some research software soon that will allow me to confirm things like that. Like how specific judges handled specific events. I thought that would be a good value to the show. But it's really expensive research software, and I have to make sure I'm not paying for stuff I don't need in it, because my use of research software is a little bit different these days than my law firm's use of research software has been for the past several years. So it takes more than a 1-second decision to pull the trigger on it. All right. But I'm hoping to have that information soon. And believe me, if I find out that that's Chupp's only TCPA case, or that he always rules the same way on TCPA, you guys are going to find out about it too. But I don't know. I gotta look into it. Next. I mean, my God, you complained why he called Vic a public figure. Yes. At the hearing, which I attended, and in the transcript, which you can read, Judge Chupp makes his public figure determination at the hearing and his ruling from the bench, sort of. He doesn't actually rule from the bench on that. He just says he is a public figure because of how many people are in the courtroom. That is not the legal standard. That argument wasn't presented by either side. That ignores the facts that the case could be public following a post hoc, post facto, or whatever determination of public figure status is improper. So if Vic was not a public figure before, but his case became popular after, he doesn't become a public figure retroactively. So again, what Judge Chupp said in the courtroom is actually incorrect application of the public figure doctrine. Now, Vic may well be a public figure, but Chupp didn't go through it, did he? And he didn't go through it in his 5-page ruling either. He just said that the court found that he was. No basis as to why. So, it will be interesting, and it might not be the case still. But yes, I do have problems with how he handled that in the courtroom. Of course I do. It wasn't the proper application of law, of the legal standard. And another commenter later clarifies what he thinks this guy means. Oh, we're going to talk about it in just a second. When there is plenty of qualifiers in his career for it. No, actually there aren't. General purpose public figures are household names. And it takes a lot to reach that household name status. There's actually case law of people who are similarly situated to Vic, where lots of their work might be known, but their name isn't for whatever reason. Outside of specific communities. Even people who do conventions based on that work have been found not to be general purpose public figures, because even though a particular community might be familiar with them, you can't go door to door to 10 houses and expect to get even 5 people to say, yes, they know who it is. You might, with Vic, here's a challenge. If you live in just a suburban neighborhood and you went door to door to 10 people and asked them if they know who's Vic Mignogna off the top of their head, I bet you most people would get less than 2 people who come even close to saying who he is. All right? I bet that to be true. Now, you go door to door to 10 people and you ask them who Tom Cruise is, and you're probably going to get 6, 7 people out of 10 to say, oh, he's that actor, maybe from Top Gun or something. This is how the general purpose public figure works. And that's what his career aspects matter for general purpose public figures. For limited purpose public figure, it's limited specifically to his involvement in the ongoing controversy. And Vic's involvement in this controversy is absurdly minimal. One minor apology that he made online after some of the stuff came out, and then one talk about it at a convention to specific people who were in a room to see him, doesn't necessarily tip all of the levers, so to speak, on how limited purpose public figure doctrine works. It might in the eyes of the court, and it would be damn nice if Judge Chupp had actually gone into that argument and fleshed it out in his opinion. But he didn't, did he? Why? Because he's lazy and because he gets bored, as indicated by his ridiculous answers on the one thing he could have done to most impact his own election. Moving on. And even more damaging, he directly asked in the transcripts Bullock under the assumption that he was a public figure based on Casey Eric's statements in the beginning of the transcript, and neither Bullock or Ty denied to refute it. Now, grammar issues in that statement aside, you're not talking about the right hearing. You're talking about a different hearing in which the matter of public figure doctrine was not being argued. So, Ty and Bullock didn't go against it because it's raised in the hypothetical and it's at a hearing that was not the TCPA hearing. And as evidence, since you want some sort of evidence as to why, neither party raised that hearing or cited to that transcript in their public figure arguments, in their filings, or at the hearing. Which means that even though you've got the knockout for the other side, none of the parties on the other side referenced that hearing transcript, and Vic's attorneys didn't do anything to address it either. That wasn't considered in the public figure determination. I get it. You're not an attorney and it's not your job to know this. But if you're trying to call it out as a gotcha, you should have your facts right. And the facts here are wrong. That transcript, I don't remember what hearing it was, but someone brings up later that was from a video in which I was reading a transcript on June 29th, which is a full 3-4 months before the TCPA hearing would occur. I'm sorry, again, you're incorrect here. You're just not right on how this works. So if the attorney apparently thinks he's a public figure, plus all the evidence in his career pointing to that, how on earth can you come to any other conclusion? Well, I just explained it. The attorneys were taking arguendo, Chupp's statements about public figure doctrine, because that wasn't the hearing in which you would actually make the arguments about the public figure doctrine. So there's no purpose in addressing them when you can address the hypothetical that the judge is presenting to you. Otherwise, you're just wasting time and money. Next. Your pretty butthurt tangent is hilarious. Do keep it up. Okay. So then, speaking of butthurt, you. Very, very childish response. I'm sorry. Sorry for insulting this guy. So then here's, I'm sorry to do this to you guys, but you guys need to suffer with me. Because here's where the source comes in. Are you ready? Pointing out facts equates to being butthurt, huh? How embarrassing. Dude, you just ranted this huge thing in a YouTube comment. Yeah, I think it was pretty butthurt. But all right. Almost as embarrassing as our last little get together where you deleted my comment proving your hypocrisy on the Jukin MXR nonsense. One thing. No hypocrisy on that. Two things. Didn't delete your comment. All right? It's okay. Keep living in your delusion thinking everyone else is wrong. I don't think everybody else is wrong. What are you talking about? Despite the numerous flaws in your arguments, one of many clear examples being the one I mentioned in my first comment about the public figure aspect. Well, hopefully you have been educated on why that argument was incorrect. In all honesty, I didn't read it until now. So, in either case, I have better things to do than arguing with a man-child whom can't handle being proven wrong. Remember this, because apparently he has better things to do. I must not, but he definitely does. Keep on spurging out, though. You make some pretty good ironic comedy. Good. That's some grade A pot calling the kettle black. How many times have you ranted about the topic? This is a new challenger, Park South. Ranted about what topic? Judge Chupp losing the election? Once, I think, maybe twice. Once on a live stream and once on this. Once on a short video for people who don't catch the live streams. I don't know. I think twice. So here we go. I didn't delete your comment. All of your boring blathering is on there despite you not actually listening to what I said. I don't even have time to approve the comments YouTube flags as spam. The function of me responding literally is timing based as to what I get in my studio. But keep being an idiot. That's what you want. It's supposed to be if. F autocorrect. So here we go. See, you can tell here I only partially read his statement because I didn't realize he was talking about the previous hearing. Way to bungle that public figure argument as well. Chupp's statement in court was, there are this many people in the courtroom, he's a public figure, which is not the legal standard. He didn't entertain the public figure arguments at the hearing or in his ruling. He just stated that he was. Chupp did that a lot in Vic's case. Both sides complained about it and are making his lack of application of legal standards issues on appeal. The fact that you don't understand this is pathetic. Now that might be rude. I'll own the rudeness there. I'll own the rudeness there. The fact that you distort what I've said on both this and MXR shows that you're butthurt. Stop being an idiot. Really? Is that why I had to repost it several times due to it magically being removed? Okay, guy, whatever you say. And what on earth would qualify it as spam? I don't know. Shall we find out? Here we go. Likely spam. Zafiro. All right. Likely spam. Are these checked? Okay, so I can approve. Look. He had another of the exact same comment. Here it is. The exact same comment is in the spam folder. It's in the spam folder. Why is this spam? I don't know. This is a well-typed out response that doesn't look to me at all like spam. But here it is, buddy. This is the exact same comment we just went through. And look, someone even replied to it. Before YouTube decided it was spam, someone replied to it. So, sure, I can approve them or not. I don't know, man. It's not up to me how YouTube does it. Here we go. Here's your Viva Frey thing, which you laid out a whole lot of... I'm not going to go through this whole Viva Frey thing on the MXR. Here's the video. Zafiro, I hope you're watching. It's in the damn spam folder, dude. I don't care enough to delete your shit. I don't care. Say all the negative stuff you want. Dude, I don't delete comments where people say terrible things about my family. I'm not going to delete your comment about MXR. Jesus Christ. Here, let's see what else is in here. This one on the Viva Frey. And then this one is... Oh, this was someone tagging him. So that's the spam. Now let's go to held for review. Zafiro. Look at this one. Another one. Another one from Judge Chupp's thing. This is held for review. Oh, here we go. This one has blocked words in it. So I didn't delete that one. But look at this. MXR. Here we go. It's in here. Blocked words. Blocked words. Look at me deleting your comments. Here's another one from you. The November 8th hearing. Blocked words. Here's another one. Blocked words. From you on reviewing the Vic Mignogna decision. Re-upload. Here's another one. Blocked words. I don't know what words are blocked. I don't know. But it's in the folders. It's there. I don't know what to tell you. There are thousands of these. All right? Total 3,800 comments. Am I going to go through them all? No. Just post it again. I don't care. Post it all day. If I see it, I'll respond. I don't think I need to go through this. I mean, we can a little bit more. I bet if I went to the spam folder, I'd find a whole bunch of them. I legitimately don't care if you post stupidity. I don't have time to filter through 1,000 comments a day. You aren't special. Get over it. And then Chad Rosman says, ouch, wrecked him with his own video. Big oofs indeed. But he didn't, though. Right. So then I asked him, tell me where to send the screenshot. I was just going to screen cap those things and send them to him. YouTube auto holds comments from users who post multiple times on the same video and with some magic words. I literally don't care what you comment, but YouTube does. I read about 1 to 5% of them due to the management system for them being broken AF and me having other stuff to do. So then he's got, if that were the case, which it very well could be, explain them why it was only the clear layout of the issues at hand in the MXR case. Let's logically walk through this. Let's logically walk through what you just said. If it's the case, as in you're taking my argument that YouTube is flagging the stuff, if it's the case, then explain why I can't. If it's the case that YouTube is doing it, I can't tell you why YouTube would do it. I don't have the ability to do that. That's YouTube. Ask Susan. Go post the comments on Wachicki's videos and ask her why they filter the contents. I don't know. What the hell would I know about why YouTube does something? You like to say you don't care a lot. And again, I'll say the same way I did last time you said such nonsense on the MXR situation. You clearly do care. You're conflating what I care about. I don't care if you just post negative comments. I don't care to delete them. I may respond to you if I see it, but I'm not going to go through and remove them. Again, I could just remove these. This thread is only showing Zephyros. I wonder if I can go. Oh, here we go. Here we go. This is much longer. We have 39 replies, right? Why is it so? See, this one's small. We keep going back and forth here. More replies. Tell me where to send the screenshot or eat shit. I don't have any reason to lie. Stop being stupid. I haven't covered up any facts. There literally aren't any more facts than have been presented. See, I don't know exactly what this is about, but I think it has to do with, I don't want the recommended side. I want the comments. If you have the screenshot, then you have the facts. Okay. So that's what he's talking about. Why won't you just upload it and link it here? Because I don't know how. I literally don't know how. If you're talking about like uploading a screenshot to Imgur, I don't know how. I'm a boomer. I'm so bad at doing anything like that. I literally can't. So I was just going to email it to you or whatever. But, I've tried with both direct links, which will get spam blocked, as well as naming it out. Well, spam block. He figured out why YouTube might do it. He figured out. Again, your video twits, transcripts, and confidentiality. Oh my! At the 1 hour, 40 minutes, and 40-second mark. Okay, Judge Chup asks under the assumption that he is a public figure. Okay, I've dealt with this one. I've dealt with this already. I didn't do it in the conversation, but I've dealt with it now on the video, so we're not going to rehash that. But the long and short is that wasn't the proper hearing to be arguing public figure status, and Judge Chup wasn't taking arguments on it at that hearing. That alone would give him indication they believe he's a public figure, thus his ruling on the matter. That's not how it works, actually. And just so you know, when judges ask questions challenging you about something, that doesn't always mean that the judge is actually taking that matter into consideration at the time. In a weird way, it doesn't. And it doesn't indicate the judge is thinking on it either, necessarily. It might not, and it might have nothing to do with it at all. Oh, it's for my benefit that I should post the link. Okay, whatever. You spent half the time now as doing what is requested. Thank you, Zafiro. That's the nicest thing you've ever said. Me figuring out how to upload a link to a screenshot that I take would take much longer than that. Fine, I'll just cover it on a live stream. And then I want to address this next comment real quick too. Because this is, I'll give you guys some tidbits, some of my wisdom or unwisdom. So, and you have no reason to lie. I can think of about 2 million subscribers worth of reasons why you would lie in favor of MXR. First of all, I didn't lie in favor of MXR. And I called out MXR for just how much damn money they were making based on a quick estimate, having never watched their channel live on that stream. And I said, these guys are not hurting for money. Not at all. Actually, I went on to argue with the chat about how much money they were making because the chat didn't seem to really agree with me that these guys were making an absolute fortune. And it's somewhere north of $50,000 a month on Patreon alone. Not to mention their monetized channel. Now, I know they have a demonetized channel, but they had a monetized channel where they do most of their broadcasting. And the monetization, we went through quick math on the numbers. They make a fortune, an absolute fortune. Good for them for doing it, but they do. And as I was calling that out, people were saying, oh, he's paying for medical school. And I'm like, that's like a month. It's like a month of their income. And he pays for their medical school. So, okay, I got it. But yes, lying in favor of MXR, what I believe I said in that video was that how Jukin Media approached that situation was incorrect, and that I had not watched the MXR videos and couldn't comment on whether or not they were fair use. But I talked a little bit generally about how fair use can work in commentary or in these reaction videos. And I said, it doesn't really matter because Jukin Media, by sending a $6,000 invoice to them after the fact, which is, or threatening to utilize the copyright system on them, is improper. It's a bad play. It's not what the system is designed to do. And it may even be extortive. And the interesting thing is, in the video, one of the videos he links is Viva Frey's video about it, or references, is Viva Frey's video, who comes to that same conclusion. I don't know what else to do other than to say, I haven't done the fair use analysis because I haven't even watched the videos. I was talking about it generally on a live stream. So, you know, you didn't, never mind. Okay. I'd like to hear your reasoning as to why you still think Vic is not a public figure, even with the evidence you went over on your own live stream. The parties didn't use it as evidence in their filings or their arguments. It's not evidence. It could be evidence. They could have used it as evidence. It would have been a bad argument because that's not what that hearing was about. So it could have been used as evidence. It would have been refuted. They would have said, or they would have made the argument that that didn't have anything to do with it. And most importantly, Chup didn't reference that hearing at all when he made his decision, either in court or in the follow-up written opinion. I know you might think that it's evidence, but it's not. And I won't go through Vic's public figure argument again. I've gone through it for a year, basically, but I've also gone through it here today. And I'm just not into it. Good God, you're an idiot. I've already said that I'd cover it on a live stream, and I've already said, or he already said that he didn't have time to argue with me, which he did quite a bit. Ugh. But yeah. So then Park South comes in, and they go back and forth. You guys can go read this if you want. But again, Park South. Thank you, Kara Pappas. saying, damn, Nick, did you have to gun the guy down on stream like that? Yes. I told him I would. So there we go. I don't know. I'm not going to go through this whole thing anymore. Always want more about the arguments. Anyway. Let's see. Going over the public figure thing just for the clarity of everyone. I don't know how to go over the public figure thing more. And this is before this video, before this live stream. I legit don't know how to say again what I've been saying for a year about the public figure doctrine. I've covered the differences between general purpose public figures and limited purpose public figures. Limited purpose public figures have to take some sort of active participation in their public affair to make themselves a public figure. It doesn't just happen. The other side can't bring about the events that cause it. So there's a whole bunch of legal arguments that go into it. And the worst part in all this is not whether or not Vic is a public figure. It's the fact that Judge Chupp doesn't show any of his analysis that he used in making the determination. The only thing Judge Chupp shows us, is just what he said in court, that because of the number of people in the room, he was a public figure, which was just a joke, by the way. And then he says the court found him to be a public figure with no basis for it. And I did complain about that as well when I went over his 5-page order, talking about how it doesn't give either party any indication of how he ruled. And that might actually end up being beneficial for Vic's appeal. Who knows? Who knows? It makes the arguments, it doesn't give you a focus for the arguments. You don't get to say that the judge applied the law wrong because you don't know how the judge got to his application of the law at all. He doesn't provide it for you. So they'll just argue that it was incorrect. And then the appeals court will, it's almost like making a fresh argument, but just using the issues you've already raised. Because the appeals court will hear the argument now. So, anyway. All right. I think that issue's done. I've dealt with it. Long story short, I don't delete comments. I don't care. Post all the negative stuff you want. Call me a bunch of racist stuff. I don't care. It doesn't matter to me. People do it all day. When you go out and you say things publicly, you're going to attract people who like you and don't like you. You're going to attract people who agree with you and disagree with you. And that is part of it. I don't have the time to delete comments. Don't care. I may engage them. No promises. But if I find a comment interesting, I'm happy to actually engage it if I have the time and if I happen to see it. So there is that. Let's get to this Chris Hook filing. It'll take me just a minute to get to it. In the meanwhile, we can take a peek at... Do I need to take a peek at that? Not really. We'll just go to this Chris Hook thing. Now I'm all worked up. Standard error, you're about to get banned from this channel, good sir. You know that CPAP smells like dirty feet. That's disgusting. Chat is too small. I can make it a little bit bigger. There we go. All right. I think the meanest thing you can actually call me is a lawyer anyway. Oh, I should provide a little bit of an update. Apparently, I made Mark Randazza mad. Mark Randazza, famed First Amendment attorney and free speech advocate, leader of the Randazza Group law firm, got really got his panties in a bunch a bit when I called whatchamacallit, Jay Wolman the gamer word, which I blame on the whiskey. I called him the gamer word. And on a live stream on Wednesday of last week. So I didn't actually mean to say it, but I did. I meant it as, or I just meant to insult him generically, and I got uncreative, so that's how that worked out. But he was like asking if I was gonna apologize. No, absolutely not. I'm not going to apologize for that. Why would I? Oh, come on, Pacer. No, not the N-word. The other gamer word. The bundle of sticks word. But, you're kidding me. Did I download this opinion? Come on. I can probably find it somewhere else if I have to. Of course, Pacer is, Pacer is not helping me out here. The Pacer case search function is broken at the moment. Let me see if I can do it on my phone and get it, Yeah, good job. Good job, Pacer. Dang it. A mess. Oh, while I'm thinking about it. Come on. Sometimes the mobile side of stuff works when the rest doesn't. It's going to. Oh, how annoying. Is it working now? Try it here one more time. Nope. Looks like I'll just get it on the mobile site. Give me a moment so I can transfer this over. Order awarding attorney's fees. Save it to all right. Whoa, trying to throw my phone around. I do have a channel announcement. We are going to implement Discord access for the Super Lawyer tier on YouTube. So if you are not on New Project 2 or Patreon, and if you are a Super Lawyer tier on YouTube, you will have Discord access as you would if you were on Patreon or New Project 2. So that is, if that's something you're interested in, that is there. I'll be implementing it and making a post on that shortly. My Discord channel moderator or whatever has gone ahead and told me that he has a way to manage that. So that will be there. So if you guys want to do that, you can. Otherwise, you can still get it, of course, through Patreon and New Project 2. But yeah. So come join the Discord. It's a fun time. Also, tomorrow will be Live Chat Wednesday, which happens every Wednesday, usually 2 p.m. Central Time. That's the target. Sometimes it's a little earlier, sometimes it's a little later, but that's the target time. And that will be happening tomorrow. And it's just like 2 to 3 hours of chatting, hanging out with me about whatever. All right. We've got Chris Hook pulled up. It's not centered at all. Let's fix that. So there you go. I can do better. It is 2019. 2020. Damn it. It's 2020. We can do even better. Every member get a free dox when you join the Discord, right? Yeah. Doxing. It's a doxing server. Doxing's for everybody. We doxed what? Trump. 1,600 pencil. Almost let it slip. All right, so here is the fee award for Chris Pay Up Gay Boys Hook, who is just fantastic. Oh, I wanted to mention real quick on the Jay Wolman thing. Is it weird that we have... Remember that Jay Wolman and Mark Randazza, these are free speech attorneys, right? Ostensibly free speech attorneys and are pro free speech. Now, out of everything I've said about Jay Wolman, and in particular on that stream, there were several insults. There were questioning his competency in handling jurisdiction and all of that stuff. They focused in on a word which I don't think applies. Like, I don't think Jay Wolman is gay. He might be, I guess, but I don't have any information to support that. So I don't know about that. Why? Like, what do you care? What about that word is particularly offensive to you amid all of the other insults? Like, I insulted his competency. I think that should make you more mad, Randazza. He's in your firm. Whatever. I'm really interested to see how his jurisdictional arguments play out. That'll be fun. Unfortunately, we won't know for a little bit. Where are we? Here we go. Okay. So this is the judge's order awarding in part defendants' costs and fees. As a brief recap of this, Chris Hook is an attorney who is representing a couple, Alan Baker and his partner, wife, whatever, significant other, I don't know, roommate, in an insurance claim against Allstate Insurance Company. Chris Hook deposed the adjuster, and he deposed the manager of the adjuster, I believe. And after those depositions, he must have believed they were going to win huge if they went to jury trial because of something that was said in deposition. So he started demanding settlement, and they didn't answer him. They did not even respond to him. According to him, they didn't respond, or maybe they didn't respond sufficiently to him. So he started to answer or reply with more emails that increased in spiciness of insults, calling them gay boys. He dropped the gamer F word a couple times as well. He was very animated in there, and eventually he implied that he knew where the opposing counsel lived or something, naming the city where they lived, which is was taken as a threat. Whether or not it should have been taken as a threat it's a matter. It's not up to me. I think they were being a little thin-skinned and used it as an opportunity to try and get the case dismissed, because, in my humble opinion, Allstate knew they were about to get absolutely pumped on this case. Now, after all this happened, Allstate has since entered into settlement with Alan Baker and his co-plaintiff. They have settled the case out and have moved for a stipulated dismissal, which means, I don't believe we get the details of that. I haven't looked at the filings, but typically those details would be confidential. And they're probably bound by non-disclosure because the insurance company doesn't want the other side to go tell other people who deal with that insurance company how much money they made in settlement. They don't want that. They absolutely do not want people to know how much money they can get out of the insurance company. And they don't want news reports saying, you know, they insured their house for $400,000, but the insurance company only paid out $100,000. They don't want anything like that. So settlements in these insurance cases are often confidential, and they have settled out. How much for? We'll probably never know. But in the meanwhile, these guys did attempt to get the case dismissed by using Christopher Hook's emails as evidence that they were very, very terrified. And the judge was 100% on their side. 100% on their side. The judge was ready to reverse his own age by about 50 years and actually put on some gloves and get in a ring with Chris Hook. He was pissed. And you can listen to the audio transcript of the hearing has been leaked out online. Or the audio of the hearing, I believe, has been leaked out online. The transcript is also somewhere. I think the transcript is out. But I played the audio on a live stream. We went through it. It would have been in late December, early January. I don't remember the exact date. But yeah, so I want to point out how in the tank the judge was. Like, he is telling Chris Hook that he's going to pay. He wants his license. He wants him to resign from being an attorney forever. All of this stuff. Because how this ends up playing out is a little bit different. All right. Before the court is defendant Allstate Insurance Company's memorandum of costs and fees against Christopher G. Hook, former counsel of plaintiffs Alan Baker and Linda Oliver. Allstate requests $41,748 in costs and attorney's fees. For the reasons discussed below, the court awards in part Allstate's costs and attorney's fees. Factual and procedural background. Now, I'm gonna call out Allstate's attorneys here. They got really lazy, and the judge is mad that they're lazy. Seems mad. I don't know. The judge seems mad that they were lazy in how they handled this. I think they got really excited that the judge is on their side and filed a bunch of BS, and the judge did not like that. That his favor was being put into. I guess, was being taken advantage of. I was like, oh, wait, we've got a justice chat from Zephiro's father. It says, Zephiro, you were grounded from the internet. I already hear what you are doing in your sister's room at night, and it has to stop. Now, that's a bit much. This Nick guy is not the person you should be taking your investual fantasies out on. Come home, you're drunk. Well, I think that's a bit strong. That's a bit strong. So, here we go. So, factual and procedural background. November 26, 2019, Shepard Mullen, on behalf of his client Allstate, submitted an ex parte application seeking dismissal of the case, disqualification of Hook as plaintiff's counsel, temporary restraining order against Hook, protective order preventing depositions, and sanctions in the amount of $63.70. Now, this is important. This was not granted. Dismissal of the case is not granted. Disqualification as Hook as plaintiff's counsel was moot because Hook was fired by the Bakers. The temporary restraining order against Hook was not granted because it was a literal ridiculous request, and the judge didn't entertain it at all. And a protective order preventing depositions was not granted either. And this, once these two things didn't happen, settlement. Allstate knew Hook was right. He knew he was going to win. Allstate knew Hook was going to win. Allstate probably knew Hook was going to win big, and they probably paid a decent grip to Baker and Oliver. Okay, so, but they asked for sanctions in the amount of $6,370. Allstate's counsel, Peter Klee, submitted a declaration indicating that he and Mark Feldman are the only attorneys who prepared the application, and they billed a total of 13 hours. The court then ordered the parties to appear before the court on December 16, 2019, and show cause why the court should not levy sanctions against Hook. On December 3, 2019, Hook filed an untimely opposition, and Allstate replied on December 5, 2019. On December 16th, Allstate and its counsel, plaintiffs and their new counsel, and Hook appeared before this court on the issue of whether the court should issue sanctions. During the hearing, the court determined that Hook had acted in bad faith and demanded that Hook pay monetary fee sanctions. Hook accepted and agreed to pay monetary fees to Allstate for its reasonable costs and fees associated with its application, which he did do that. He did say he was going to pay. The court granted monetary fee sanctions against Hook and ordered Allstate to prepare an application for costs and fees up through the hearing date. On December 31st, 2019, Allstate filed its memorandum for costs and fees in the amount of $41,748, a sharp increase from its initial request of $63.70. The court now determines the amount of sanctions it shall impose. So this sharp increase, that's a warning word. He's not going to award that much. And it was ridiculous to ask for almost 7 times the amount. Almost 7 times the amount. See, a district court has a primary response. So this is a legal standard. Has a primary responsibility for controlling the conduct of the attorneys who practice before it. When an allegation is made that an attorney has violated his moral and ethical responsibility, an important question of professional ethics is raised. It is the duty of the district court to examine the charge, since it is that court which is authorized to supervise the conduct of the members of its bar. The courts, as well as the bar, have a responsibility to maintain public confidence in the legal profession. This means that an attorney admitted to the state bar may be disciplined under the court's inherent power for conduct that violates the state bar's rules of professional conduct, including conduct that occurs outside court. Accordingly, a fee award under the court's inherent power is meant to vindicate judicial authority rather than to provide a substantive remedy to an aggrieved party. So these are punitive for the court. Now, the other party gets the benefit, but the court is not there to make the other party whole. The court is there to punish the bad behavior. There's a slight difference there. Because if it was there to make the wronged party whole, then whatever they submitted, so long as it was reasonable, would be the award. But that's not how the court has to operate. You sent me the Christopher Hook audio. I think I have the Christopher Hook audio, but thank you. Thank you. We already, I think I have this from way back when. Somewhere. But yeah, thanks, man. I very much appreciate that. So let's see. Accordingly, here we go. Nevertheless, a court may impose attorney's fees and costs that are necessary to compensate the innocent party, to vindicate the affront to the court, and to ensure that such abuses are not repeated. Thus, the court may award attorney's fees when the interest of justice so requires. Still, the fee award must relate to the bad faith conduct involved. For an award of a monetary sanctions, the court must determine a reasonable hourly rate multiplied by a reasonable number of hours. Generally, in assessing attorney's fees, the court should calculate the lodestar figure by multiplying the number of hours reasonably expended on the litigation by a reasonable hourly rate. That reasonable gives the court a ton of flexibility. And imposes a burden on the requesting party to prove up the reasonable nature of their request. So it's not just we're going to take your word for it. You have to put down on paper what made it reasonable. And if they don't do it, the court's under no obligation to listen to them. Oh, Gelth, want to see the results of the fire to my house and car? Oh, from the Aussie fires? Crazy. I might pull it up in a little bit. Okay. After computing the lodestar, the district court may then adjust the figure upward or downward, taking into consideration the 12 reasonableness factors, which are all listed here. Accordingly, the court may reduce an attorney's fee award where the documentation is lacking or where the hours billed were excessive, redundant, otherwise unnecessary, or not reasonably expended. So let's check the reasonableness factors. We'll just burn through them. Time and labor required, novelty and difficulty of the questions involved, skill requisite to perform the legal service properly, preclusion of other employment by the attorney due to the acceptance of the case, the customary fee, whether the fee is fixed or contingent, time limitations imposed by the client, or the circumstances, the amount involved and the results obtained, the experience, reputation, and ability of the attorneys, the undesirability of the case, the nature and length of the professional relationship with the client, and awards in similar cases. So those are the 12 factors. Discussion. December 16th, the court determined Hook acted in bad faith by sending numerous profanity-laced emails using discriminatory epithets. Not epithets! No! No! These are lawyers! I have to go back to that. These are lawyers. Being called a lawyer is almost a discriminatory epithet in and of itself. These people are supposed to have thick skin, Jay. They're supposed to have thick skin. They're supposed to just deal with it. Fire back. Who cares? They're very hurt by these mean words and emails. And repeatedly threatening physical violence against Allstate's witnesses, attorneys, and their families, purportedly as negotiation tactics. I think even here the judge is overplaying this. There was no actual threat of violence. And they went into court asking for a restraining order based on the threat, and the judge actually didn't grant it because there wasn't a threat. Nothing legally. Accordingly, exercising its inherent powers, the court ruled that Allstate was entitled to costs and attorney's fees for bringing its application. At the hearing, Hook also agreed to pay monetary sanctions. Accordingly, Allstate now moves for costs and attorney's fees in the amount of $41,748. Hook opposes a memorandum and requests that the court award Allstate no more than its original request of $63.70. So here's a Lodestar analysis. Shepard Mullen, who represents Allstate, had 3 attorneys bill on this matter at the following rates and for the following number of hours. Peter Klee, $490 an hour for 16.8 hours. Mark Feldman, $490 an hour for 46.8 hours. This is just a fee request for sanctions. And they're saying that these 2 dummies put in 63 hours of work. That's over a work week. That's a work week and a half on a fee request. And then this guy, Jack Burns, at $420 an hour, an additional half of a work week. Just crazy. Crazy how much they purported to work on this. And this pisses the judge off a little bit. Accordingly, Lodestar proffered by Shepard Mullen is $41,748. Quote, when faced with a massive fee application, the district court has the authority to make across-the-board percentage cuts either in the number of hours claimed or in the final Lodestar figure as a practical means of excluding non-compensable hours from a fee application. Also quoting, when a district court decides that a percentage cut to either the Lodestar or the number of hours is warranted, it must set forth a concise but clear explanation of its reasons for choosing a given percentage reduction. So hours expended. Foremost, Klee's initial representation of this court, made under the penalty of perjury, is that Shepard Mullen billed 13 hours to bring the application before this court and requested $63.70 in monetary sanctions. Shepard Mullen now seeks a do-over by asserting that it actually expended 33.2 hours to bring its application. So Shepard Mullen now asserts that Klee billed 4.6 hours, Feldman 19.3, and Jack Burns 9.3 hours to bring the application, when it previously asserted that Klee billed 2 hours and Feldman billed 11 hours to bring the application. The judge is polite here. He just called them out for lying under oath in one of the 2 places, either under its original application, which is made under penalty of perjury, or its subsequent filing, which is also made under penalty of perjury. So The court denies Shepard Mullen's attempt to backdoor an additional 20.2 hours, which appear punitive, you think. After it represented the court, it only had spent 13 hours to bring its application, a representation that the court relied upon in granting monetary sanctions against Hook. So then they actually quote Goodyear Tire and Rubber Company versus Hager, saying, holding that attorneys' fees awarded as a sanction for bad faith conduct must be compensatory rather than punitive in nature. Accordingly, the court excludes the additional 20.2 hours, which just saved them, Chris Hook, a boatload of money. Like $8,000. Good job. Further, Shepard Mullen's costs and fees records include 4 billing entries that provide no description, merely state privileged, and amount to 3.7 hours. Shepard Mullen asserts that Klee billed 1.8 hours as privileged, Feldman billed 0.2 hours as privileged, and Burns billed 1.7 hours as privileged. Without more, the court cannot determine whether the time expenditure is reasonable, and accordingly, the court finds that Shepard Mullen is precluded from recovering those hours. Shepard Mullen also attempts to recover 4.7 billable hours on times that do not necessarily pertain to Allstate's application. And it's interesting because 4.7 hours doesn't sound like much until you realize that at their billable rates, 4.7 hours is $2,000. No, wait. Yeah. Yeah, about $2,000. Which include researching plaintiffs' new counsel's rights and reviewing media. Again, the court finds that these hours were unnecessarily incurred. Shepard Mullen asserts that Klee billed 0.6, Feldman 3, and Burns 1.1 hours on researching plaintiffs' new counsel's rights and reviewing media. So basically, they said that none of that relates to the bad faith conduct. After reviewing Shepard Mullen's costs and fees records, the court finds the hours to be excessive and duplicative. Specifically, Shepard Mullen engaged in block billing. For example, 5 billing entries exceed 4-hour blocks. Additionally, although there are only 3 attorneys billing on this matter, the billing records are riddled with duplicative entries that include reviewing prior filings and case materials. Therefore, the court finds that a 10% reduction for block billing time entries is warranted and an additional 10% reduction for duplicative entries. So what he does is he's not going to go through each block and remove them. He's going to apply an overall reduction of 20% to the award. Lastly, the court imposes an additional 10% haircut reduction to Shepard Mullen's fees. Citing Moreno versus City of Sacramento, a district court can impose a small reduction no greater than 10% a haircut based on its exercise of discretion and without a more specific explanation. So he gives him a 30% overall cut, 10% being purely discretionary. And think about where this case was just a couple months ago. The judge is saying, I'm gonna have your head. I'm going to have your head. I'm going to have your license. I'm going to make sure you don't ever practice law again, to now reducing their hours by the maximum within his discretion without providing an explanation. That's just a testament to how poorly, or how unimpressed he was, I should say, with their filing. You have this guy, and all you have to do is provide a reasonable filing, and he can't even do it because lawyers are all greedy piles of garbage. Accordingly, the court reduces Klee's billable hours to 8.3, Feldman's billable hours to 24.9, and Burns' billable hours to 9.2. Hourly rates. Now he gets to determine whether the rates were reasonable. Next, the court assesses whether the hourly rates charged by counsel are reasonable. To determine whether hourly rates are reasonable, courts may consider whether the requested rates are in line with those prevailing in the community for similar services by lawyers or reasonably comparable skill, experience, and reputation. The relevant community is the district in which the adjudicating court sits. The party seeking attorney's fees may satisfy its burden of showing that the proposed hourly rate is reasonable by submitting affidavits of counsel or affidavits of other counsel in the relevant community and by providing case law examples of the relevant community rate. Shepard Mullen has provided no evidence addressing prevailing market rates and rate determinations in other lawsuits. Thus, it has failed to establish a satisfactory market rate for its rates. So again, They were relying on the judge being on their side. The burden is on the fee applicant to produce satisfactory evidence, in addition to the attorney's own affidavits that the requested rates are in line with those prevailing in the community for similar services by lawyers of reasonably comparable skill, experience, and reputation. Klee provided no information to establish his and Feldman's hourly rate. Court recognizes the time necessary to prepare filings in this matter, but the application and fee requests are not particularly complex or laborious. For instance, Shepard Mullen billed 17.9 hours for travel time and straightforward research, tasks which do not require great litigation skill. Accordingly, the court finds the rates sought by attorneys exceed those merited given the skill required in the present facts. Shepard Mullen has failed to justify why partner Klee and Feldman deserve to bill at a higher rate than partner Burns. Accordingly, the court lowers their rates to match partner Burns. Now, this is generous. He just cut $70 off of each of their rates. He could have lowered all of them. This is him still being pissed off at Hook because they didn't justify why $420 an hour is reasonable. Does that sound reasonable to you? Oh my goodness. Let's see. Accordingly, the court recalculates the Lodestar award at $17,808. Because the parties do not request a multiplier or reduction factor, the court declines to apply such factor. Accordingly, court grants an award of $17,808 in attorney's fees. For the reasons discussed above, the court awards in part all states' requests for costs and attorney's fees, the amount of $17,808. So a little under 3 times the initial requested amount of $63.80 or whatever it was. What was that? $63.70. A little bit under 3 times that amount. So there you go. They did not get it. I can't comment enough on how poorly they did. They had everything in their favor. The judge is 100% on their side, and they end up with this because they were overconfident in the judge's anger, overconfident in his favor towards them, and they didn't do the proper work. They didn't put in why their rates were what they were. They didn't justify their billing. They could have tried, could have put more effort into it. It looks like, I'm not going to accuse them of this, but I think the judge saw the same thing. It looks like you saw you were going to get a fee award and you padded the bill. Now, I mean, where have we seen that before? Where have we seen that before? Yeah, I think you guys know. But it looks like they knew they were going to get a fee award. They padded the bill. Judge is not happy about that. Judges don't like having they don't want an appearance of impropriety. They don't like having their integrity challenged or put, not even challenged, taken advantage of. They don't want that because this might have to go before an appeals court. I don't think it's going to. I think Hook should be probably pretty happy with the fee award he got. I don't think it's going before an appeals court, but it could, in theory, go before an appeals court. And if the judge looks like a vindictive pile of garbage who just let the plaintiffs walk all over the defendant, or walk all over, not the plaintiffs, let one party walk all over the other party because of how the judge reacted, that's not going to look good. They can't do it. So there you go. That is the Chris Hook situation. I wanted to give you guys an update on that. I would love to interview Chris Hook. I don't think he's going to do an interview on this ever again. I would love to, though. We don't even have to talk about this. He just seems like an interesting guy. Guy who's pissed off at the system that he was in. And insurance companies are terrible. Objectively awful to deal with. They spend... What is happening? What? Again? All right, guys. Chair Coon is on the scene. I'll be right back. Okay. All right. Welcome back to me. Oh boy, sorry about that, guys. Just dealing with fun stuff. This is just a funny thing, I guess. This is a funny thing that we'll cover. So here you go. This is in Vic's case, Court of Appeals. Victor Mignogna versus Funimation Productions, Jamie Markey, Monica Rial, and Ron Toye. And this is to Casey, Andrea, and Rusty O'Kane. So this is to Ron and Monica's counsel. We received your appellees, cross appellants, unopposed motion to enlarge time and file briefs on May 3rd, 2019. Oh, they got that on May 3rd. What? How the hell did they get this on May 3rd, 2019? That is absolutely not true. Oh no, Court Coon, you definitely got that one wrong. That's not even in the ballpark. They got it. It's filed on March 6th, 2020, which is not May and is not a third and is not in 2019. They literally got all three wrong. No, appeals court, no. Don't do it. Don't do it. She'll never love you. Don't simp. Oh. Whew. Okay. We know what they mean. They likely have a template and either click the date wrong or were copy and pasting from something else and just left in the wrong date. Something like that. Oh, excuse me. But, wow. This motion does not include a $10 filing fee as required by the Texas Supreme Court. $10. Oh, man. Now, give me just a second here. I want to show you guys something. They're doing this on purpose. All right. Do you want to know how I know they're doing this on purpose? I'll show you. And it's cute that they are doing this on purpose, but it doesn't affect me that they're doing it on purpose. I don't know why it's a dumb game. Again, they're the idiots who blow everything out of proportion. Like, again, I'll go back to when Ty and company made their initial request for an extension. Their side categorized it as begging with open hands for an extension when it was literally just, hey, do you mind if we extend this? Yeah, of course, no problem. And then, oh, Ty came hands out begging. They got uncircumcised neck T Greg to come out and try and blow that out of some sort of proportion. But here you go. Notice this was on March 9th at 5:28 p.m. This letter was sent out on March 9th. It doesn't have a timestamp, but you can assume that it was around that time. And Lemoyne, big news equals big mad. Countdown T minus 5760, which would be, I would assume, the number of minutes until my show tonight, something like that. Saved by the Bell may never be the same. This is a reference to Lemoyne calls me Dustin, aka Screech from Saved by the Bell. I guess he doesn't realize that Screech was the smartest person on Saved by the Bell. I don't know. It doesn't bother me that they call me Screech or Dustin. But this is the level of creativity from these people. So there you go. Good job doing that on purpose. I hope the court never figures out your little code. That would be really unfortunate to see that they saw you guys actively doing stuff intentionally to cause delay and to make the court send out letters and stuff like that. That would be a really dumb game to play for no profit for you guys. Screech might be at GaryCon. Wait, the actual Screech? If you're you better not be kidding. I will get a picture with that guy all day. I didn't even watch that stupid show. But I would love to go take a picture with him for the memes. All of the memes. All right. So anyway, that's what's going on in Vic's case. Long and short, they have until they didn't include the whopping $10 filing fee. And they have until Thursday, March 19th. Of course, they're going to do that. And their motion is going to be granted anyway. Because extensions in appeals are not a big deal. They happen all the time. It's just how it goes. So there you go. They're going to definitely submit that $10 fee. Even if Ron has to rub one out, someone else, right? Even if Ron has to do that number, has to find the bull and prep him a little bit for that $10. Just as long as you leave the house, Ron, here you go. That's how that'll go. But anyway, so that's the main content we have for today. Alex Jones has been pulled over for DWI. Expect a short video on that. It's a really interesting thing for Jones. He made some wrong moves in his DWI case that may end up burning him. They certainly make the case a little bit easier on the prosecution that he didn't need to do. But we'll talk about that a little bit in a short video. Like I said, I'll try and get that out tomorrow. But yeah, Alex Jones got pulled over for DUI and charged with DUI, which is it's a misdemeanor in Texas. I don't know off the top of my head what the penalties are for it, so I don't want to say what he's facing, but I would imagine it's probably just a fine and maybe a temporary suspension of his license, maybe not. I'm not sure on that. There's some interesting stuff about the case, some problems for the prosecutor, but Jones gave them ammo he didn't need to give them, and that was a little bit of a mistake for him. So we'll talk about that, and we'll talk about what you should do if you get pulled over for a DUI, and that is to contact an attorney in your jurisdiction for actual legal advice. But I'll give you some things to think about that you can talk to an attorney about in Texas on that short video. That'll be, like I said, should have that out tomorrow. In other news, E3 has apparently been canceled. So I don't know what maybe all the AAA game companies will now take the money that they would have spent on E3 booths and they will dump them into their games as opposed to just their advertising for the games. Who am I kidding? Of course they won't do that. But E3 has been cucked by Corona-chan. She claims another victim, and she will not stop. She will not stop. So South by Southwest in Austin was also canceled, I believe. So, I mean, coronavirus is kicking the ever-loving shit out of America right now. It's dumping stock markets. It's canceling major industry events, major cultural events. It's got people terrified. But that's what I got. Other non-content related stuff. Who out there? Are any of you guys going to GaryCon? I am going to get there Wednesday evening. I don't know if I will make it for the pre-show party or whatever, but I will hopefully be there Wednesday evening. I'm going to try and do something from the convention recording-wise. I'm not a guest of the convention. I'm a guest of someone attending the convention, but I'm not a guest of the convention itself. So I don't know what kind of access I'll have. But I won't have any duties at the convention. I'm just there to hang out and have fun with people. So if you guys are going to be at GaryCon, I will be there all 4 days. Thursday, Friday, Saturday, and Sunday. I may be there the Wednesday before. I will hopefully get some sort of, maybe I can interview someone or something. We'll do something like that. But it should be a really fun time. If you're there, come find me. I will be there. So come find me. And Lady Raggets will be with me. Maybe I don't know if we're going to get in on a D&D game or whatever. I believe also Ty Beard will be at GaryCon. So if you can't find me, find Ty Beard and you'll find me then as well. So I probably can get a press pass, but I haven't talked to them about it. But come find me. I love just hanging out. That's what I'll be there to do. Hang out, enjoy the con, have fun. I've been having fun playing D&D on Twitch, on Inverse channel. I would love to have the time to play more D&D. Always liked it. I've always been interested in it. And lately I've been watching a lot of D&D lore videos and stuff like that because I'm a huge nerd at heart. I just don't have as much time as I used to. But I've always enjoyed D&D. And also, if you have a set of the Encyclopedia Magicas, yeah, you know what I'm talking about. From the 90s, the like fake leather bound Encyclopedia Magicas is like a four book set. If you have one of those and you're looking to get rid of it, DM me. I will pay you for it. So, because I love books. Those were fun, man. So anyway, and second edition was where I spent a lot of time as a kid, reading about it and all of that stuff. Check out Pathfinder second edition, great system. Yes. Pathfinder. Speaking of Pathfinder, I am hopefully going to do something related to Pathfinder Wrath of the Righteous, the new game that is coming out. And so I hope to... I've talked a lot about doing a second channel that is not law related, but is more just escapism. I think that's what it's going to be, escapism related stuff, where it's more general commentary and stuff like that. But for topics that aren't legally related but are interesting to me. So look for that soon. And as a kickoff event, I have something that I would like to do to kind of direct people over to that channel. So there you go. That's that. I think we're about done for the evening, other than chats, right? I'm going to go through the super chats and the justice chats, and then we'll call it a night for tonight. And we will, we'll have a show tomorrow. We'll get something on the books there and keep going. keep going. Will the new channel have big anime titties? God, I hope so. Don't we always want that? Gaku says, hey Nick, love the work. Just wanted to give a shout out to a YouTuber who was censored from his video about the rise of anti-Semitic attacks in New York. His channel is Louis Laveau. Thanks for everything. I've heard that name. Louis Laveau. So yeah, there you go. What is this? Hold on one second. All right. Yeah, I feel like I've seen Louis Laveau or heard of him. I don't know. Yes, I will be on Twitch tonight, failing at Sekiro even more. Sorry if you have to endure that. It is it's embarrassing for me. It's more embarrassing for me than it is for you. Than it is painful for you. Oh. All right, let's go ahead and do these chats. A reminder as I do these chats that the super lawyer tier, the $9.99 tier on YouTube, will have access to the Discord in very short order. So if you are interested, if you don't like Patreon or New Project 2 for some reason, and you like YouTube for some weirder reason, and you want to be a super lawyer member on the channel, that will have Discord access included with it. I'll see if I can get it implemented tonight or tomorrow before the live chat Wednesday. Also, there will be another Cooking with Racket stream for members on any one of the 3 platforms. The Cooking with Racket stream will be coming up sometime soon. And in this one, I will make a recipe with a roux involved to put down the haters. To tamp down on the haters and naysayers harder than the Chinese government. Watch out. I've got tanks rolling on the haters sometime soon. Maybe in the next week or 2. Before GaryCon. Oh yeah, Gelf, you sent me a thing. You want me to show your picture of your house and car. Oh my God. It's not a house, Gelf. It's just a pile of freaking rubble. What's wrong with you? We'll get these pulled up here. All right, real quick, let's show you guys the Gelf things. Here you go. That's Gelf's house. I don't know. It doesn't look habitable. But you know, that house behind it seemed to fare much better, but this house did not. So that's a mess. And then here's the car, which is just in, you know, completely burned out. So, man, that sucks, buddy. I'm sorry that your entire continent is trying to kill you as much as possible. Very, very frustrating. You know, you evaded all the poisonous stuff only to have the fire come. So. So there you go. I like what you've done with the place. Aw, come on. If I can get a pic of the house next door, should see their damage. Your house was just rubble. What could be worse? Did it like actively kidnap their children and eat them or sacrifice them to Molech or something? Oh my God. Okay, anyway. So going through the, let's do justice chats real quick. We've got Xander's Rant says, did you see who Mr. Masterson had on as a guest? When are you going to have that person on? Also, when are you going to have Doug on? Who did Dick have on as a guest? Oh, dang it. No, I didn't. Hold on, let's see. Stefan Molyneux, huh? Oh my goodness. Stefan Molyneux. Crazy. I'd like to talk to him. I think he's got mom issues or whatever, but he's an interesting guy. Drexel's Man Bun says, Kenshi, prepare to have all your hopes and dreams crushed. It's worse than Dark Souls, especially in the beginning. Oh, thank God. Oh, thank God. Kay says, hey, Nick, never get a chance to watch your Twitch stuff, but I have a game recommendation. Doom 2016. Oh, I just beat it. I just went through Doom 2016 on Twitch. You can actually go on Twitch and watch them if you want. I know if you don't have time to catch the streams, you probably don't have time to watch the replays, but they are there. I played through the entire game on Twitch, on the ultra violence difficulty. I didn't play on Nightmare. You can see me try the ultra nightmare or whatever after I beat the ultra violence, which is just a joke, but because I wasn't going to go through that game without dying ever. That's ridiculous. But yeah, I played it. I had a lot of fun playing it. It was good times. First try on every single encounter. Hands down the best single player shooter in years. The sequel is out in 9 days and it looks even better. I think it's right up your alley. Yeah, I'm going to play some Doom Eternal at some point. Right now I'm trying to get through Sekiro. Kay also says, a layman arguing with a lawyer over the lawyer's statements is like bringing a stick to a bazooka fight. Yikes. That's why I don't like doing it, by the way. That's why I don't like doing it, because I have this stupid, unfair authority, which is it's just a piece of paper and like a $200,000 education. But literally, that doesn't mean as much as people think, right? That's why I don't like arguing with people about stuff. I'd much rather just discuss things and get people's opinions. I know it seems weird and counterintuitive, but I don't like arguing with people about stuff. I will entertain disagreement all day. I just like to talk to people and have a much less confrontational or hostile discussion. So, Flandre Scarlet says, of course, most of that was flagged as spam. Duplicate, miles-long lorem autism posts are going to get flagged, especially if they keep trying to post them quickly, because they 100% wrote those in a text editor to paste in for total luxury spurred posting. Yeah, I don't know. What I do know is I definitely don't go through and delete stuff, because, oh my God, you'll get called out on stuff like that, and there's just no profit to be made going through and deleting stuff. It's like going against, or like trying to defend yourself from insults, which I know I did kind of do there, but it wasn't that much. Like, it wasn't that useful to me to do. It's just annoying as shit. Kay says, too bad the judge was demonstrably vindictive, so he's going to do whatever they can to punish Hook and keep him from practicing law, as they literally said in the courtroom. Huge red flag for me. Yeah, it is for me too. And I think the judge actually probably regrets saying that, because he probably had to temper his award by a bit. Troll with a Purpose says, we're Nick's parasocial relationship and not the other way around. Creepy. Yes. Yes, 1,000 times yes. I live in the middle of nowhere. I haven't seen another human in days. Siren Jag says, how is it May 3rd, 2019? Well, it's just a jump to the left and then a step to the right. With your hands on your hips, you bring your knees in tight, but it's the pelvic thrust that really drives you insane. Let's do the time warp again. Okay, come on. Okay. Now on to the super chats. Diesel Mechanic 88, welcome to being a super lawyer, buddy. Look for the post on the community page, which will have instructions for the Discord. That'll be coming like tonight or tomorrow morning, something like that. Chengiz Khan, welcome to the channel subscription as well. Snack Sheet says, message deleted by Rekieta Law. You son of a bitch. And then he says, Rackets, why? It wasn't me. It was YouTube. YouTube did it. Gotcha, son. You're a wrench for the quartering, huh? Oh, man. I need to have a drink off with Jeremy sometime. Charlie Spur says, shout out to Sword Yoshi. Hey, what's up, Sword Yoshi? Big ups to Sword Yoshi. By the way, if you didn't see my DSP bankruptcy video, I'm sure you guys did. I released it early yesterday, yesterday morning, whatever it was, like 2 a.m. or 1 a.m. or something. That was purely waiting on the thumbnail, and there were some complications with it, but it did go out. It's up. If you want to follow along with DSP's bankruptcy case, there was just a small update there, and you can check it out. But I will be watching that case very closely. Yeah, Tillip, you're bad indeed. I wasn't throwing you under the bus. I should have done that harder. Mario Carter 13 says, last time Nick came early, he needed a bigger van. Stop it. Stop. Delete that comment. Also true. Razor says, betcha the real reason DSP didn't show for the meeting is because the only formal clothing he had was his wedding suit. Aw. I think he's worried. He's got to get that filing in order. He's got until March 26th, and he better amend that filing appropriately. I think he's going to be asked some hard questions by the creditors and the trustee. There's a lot of people who think it would be funny to troll DSP in his own bankruptcy pleading, or his own bankruptcy case. Angry Baneling says, Nick, you're streaming today. Thank you. May you be blessed with less or more boomerism on your next Twitch session of Sekiro. I've got to fight the bull tonight, and I'm going to die endlessly, and it's going to suck. Tippy Tail McKitty said, would you like some locally made mead at GaryCon? Yes, yes, yes. Yes, of course. I would love that. Chenghis Khan says, don't you remember, Nikki? You're the ultimate grifting mastermind. If you have time to scheme an entire court case to grift your money via GoFundMe, you have time to delete comments. Lol. You're right. Guilty. F. Roblin the Goblin says, I feel like live streaming and the people watching, interacting are so attracted to this because of our scattered, overly stimulated, lonely lives. I think so too, and I like it. Angry Baneling says, I delete comments. You delete comments. Well, wait, that's you saying it, Angry Baneling, not me. Nero Altai says, DC Douglas is a predator. Like with the... That kind of predator? Some nobody says, go get Nio while it's on sale for $15 also. Didn't they just release Nio 2? Or that's coming out? They either released it or it's coming out. I don't know. Daddy LP says, an Egger stole my bike. Sakagi Onsai. Oh, come on. No. Sakagi Onsai says, there is no TP for our bungholes. Beavis. That's true. That's true. Batosia 34 says, what do you think about the historical balance in divorce court between male female? Do you see it changing recently? The historical balance is largely in favor of females, and there's some reasoning behind it, right? The reasoning behind it was that men tended to work and females didn't, and when they got divorced, they wanted to compensate the trad wife. Importantly, they wanted to compensate the trad wife for being there while the husband worked and taking care of the home. I mean, that's why divorce court is like it is. And there are moves to remove that bias in favor of women. They're not very effective. They take a generation or two to breed out, basically. But the trad wife was there keeping track of the home, taking care of the children while the man went out and earned money. Nouveau feminism says that that is wrong and bad and disgusting, but still wants the trad wife treatment, right? They want to go work, not take care of the house, not take care of the kids, go work alongside the man, but then take the man's income when they do the divorce. This is the problem. that we have is we've changed the understanding of gender roles. And that's fine if you want to do that, but you don't get to stick with the old accommodations for the gender roles, or you shouldn't get to stick with them. Do I see it changing recently? I mean, there are legal changes made by some Congresses. For example, in Minnesota, they're not supposed to consider the gender roles of the parties. It's the presumption is on 50-50 splits, and there's a disfavor of things like marital maintenance and stuff like that, spousal maintenance. But they still overwhelmingly support the female in custody awards, which overwhelmingly supports females in child support awards. And like I said, it's going to take a lot of judges aging out of being judges before that actually gets changed. It's generational change. It doesn't get changed by the stroke of a pen. So, hopefully that answers your question. Red Pirate 115 says, are you sure Corona Chan hasn't visited your kids? No. I mean, I can't be sure of that, but I'm not aware of coming into contact with Corona Chan. On a more serious note, hope they get better soon. It seems like pretty normal kid stuff that just runs through kids when they go to, they go to an event with other kids and then they come home and suddenly their immune systems have to adapt to all the stuff that we've adapted to over the past however many years we've been alive. We got all the same crap as kids. That's probably why I don't get it as often as my kids get sick. And then I don't tend to get sick as often, but I do have to deal with them. So Apollo 26 says, sent you a DM on TW in Colorado. Any help is appreciated. DM on Twitter in CO. I assume that's Colorado. Also, someone sent me a thing about Pathfinder Kingmaker. Yeah, I know. I played Kingmaker on Twitch several times. I really liked it. And yeah, I like Owlcat Studios and what they've done. I think I really like what they did with the game. I think it's great. I think it's a really good game, and I'm looking forward to Wrath of the Righteous. So thank you for sending me that. But yeah, I've played it on Steam several times. That game is hard as shit. Okay. Sorry, sent you a DM on TW and CO. Any help is appreciated. Apollo 026. I'll see if I can find it, buddy. Keck7 Go says, people who write novels in YouTube comments need to get their heads checked. That's true. Most of the time, they're not going to see your novel. There's just too many comments for it. Mario Carter 13 says, voters don't do job. Quote, I learned it by watching you. I learned it by watching you. And Frog says, I have electile dysfunction. I can't elect. Verticon says, thank you, Nick. That meant a lot. Hey, you're welcome, buddy. Moist John says, starting to get more into rum recently. Ever try Pampero Aniversario? No, I'm not a big rum drinker. So if you ask if I've tried it, the answer is almost guaranteed to be no. Some nobody says, please spare us this Fugat. Nobody cares. I know, but I care, which is dumb. I'm not supposed to, but I do. Nero Altais. Zeph says no time. Also, Zeph writes manifestos. Some nobody says that's Hunter Biden money MXR was making. Yeah. Is making. MXR is making a fortune. I think we may see some changes to how fair use works in reaction videos, though. I think the Sargon video helped. I really do think it helps fair use people. And I didn't talk about this too much, but the judge said, if you're going to Sargon's channel, there's no way you're in the same market as the original video for Aquila. And there's no way you reasonably think that you're getting the same thing. I think you can extend that argument to reaction streamers, even if they're not doing really good fair use commentary. Like, oh my God, my daughter comes up to me today and asks to watch a YouTube channel. And it was a reaction channel. And the guy is doing everything wrong. Like, as far as the fair use analysis, it's a huge problem. He's just literally pointing out what is interesting about the video. He's not critiquing the video. He's not adding anything to it. Like, one of the things he watched is like luckiest people on earth or something. And an owl flies into someone's car while they're just sitting there and then just hangs out in the car. And he's like, whoa, that guy's so lucky. Like, how does an owl fly into your car? Owls are cool. Owls don't fly into cars. That's cool that an owl flew into his car. That's not fair use. That's not critiquing. That's not transformative. He's literally just pointing out what happened in the video, which is exactly what that case I went through before with Juke and Media. I went through and talked about how the videos have to add something to it. They can't just be pointing out what about the video is interesting to be transformative. But at the same time, people are going to these channels to watch that stupid reaction. They're going to the channel to see that dummy react. They really don't, they're not looking for the owl video, right? They're not just like, oh, I want a 6-second clip of an owl going in the car. They want to hear Captain McAsshole talk about how cool the owl is going in the car. That's what they want. And the same thing with MXR. They want to hear Ginny react to something. I don't know the guy's name. That's why I always say Ginny. They want to hear a generic guy react to something. That's why they go. And I really don't think that their reactions are preventing the dissemination of the product or impacting with the market, because their reactions are the market people are entering. And I think we're going to see arguments around that as these things continue to happen. And I think that's why MXR was happy to go ahead and settle out their issues with, or why Juke and Media was happy to settle out their issue with MXR. I think that any of these content farms are going to be afraid of that argument coming up, because it's a good argument. Otherwise, I wouldn't ever watch the video. I wouldn't read the Reddit thread unless these guys are reading it to me. That's the consumer. And that's crazy. It's crazy to think of how they're going to have to deal with that. But anyway, I was thinking about it today because my daughter was watching this video and the video was trash. It was so pointless. It was just a guy saying it was great. Good. Oh man, this is cool. That guy's so lucky. That's literally what these videos are called. It's about being lucky. Whatever. All right. Sorry. Tracy Dealman, welcome to the channel membership. I appreciate it. K. Shiloh Williams says, hey, Nick, I'm ordering some crazy Alice cigars. Was wondering if you'd be interested in trying one. I don't know what those are, but yes, I would love to. Rando number 9 says, Nick, the hard R superstar Rekieta. Oh, no. Bro Tato, welcome to upgrading to lawyer status. Pretty soon you can upgrade to super lawyer. That'll be great. Corey Goodman, welcome to being a super lawyer. Glad to have you. Will be interesting to have you in the Discord soon. JC Gaming says, confirm J is a British cigarette. There you go. Some nobody says, almost like they're bad people who deserve to be berated. Well, yeah. All people are bad who deserve to be berated and deserve to be berated. BTL Video Production says, so Chaircoon, you come here often. Why not drop the 0 for a real man who will sit on you real nice? Like, listen here, you. How dare you? You think I wouldn't see this? Carapapa says, I want Chaircoon to sit on me. Now that's a little bit different. Bro Tato. Oh, and he upgrades to super lawyer. Welcome to the channel, pal. We'll get that. I'll try and get that Discord link out. Look for it on the community tab tonight or tomorrow. I have to just double check how my whatchamacallit, Discord supervisor likes to handle things. Because he's the one who does all the maintenance of it. It's superstar, really. I gotta buy him lunch. It's Cocky Onsai says, it's called the Wuhan virus. Ted Lieu can go Minecraft himself to bring up racism. It's not racist. It's factual. Herp-a-derp that he is. Oh, yeah, I saw that. They're like, why is it called the Wuhan virus? That's racist. Because it originated in Wuhan. Like, that's why. Other viruses are named for their origination point. Curious Items Inside says, hey, Rackets, when's the time skip in this saga? I don't know what that means. TLJ Screwjob says, any update on having that uncivil law guy on? I'm going to email him probably tomorrow. So I don't know, whenever he's available. I'm interested to have the conversation with him. From what I've heard, he disagrees with me on some stuff, but he's not hostile. And like I said, not super interested in having hostile conversations with people. I'm fine with disagreement. I don't want to come on here and get angry with someone or whatever. Fighting is annoying. Plus, the last time I was supposed to disagree with and argue with someone was that Vince guy, Vince James, and he just kept saying the same damn thing over and over, and I wanted to eat a physical copy of Minecraft and choke to death. TLJ Screwjob says, wow, the bull didn't know Drexel was in Sekiro. Oh, you haven't played then. Bad Dragonite says, do your best Captain Falcon taunt. No. Tarapar says, is Goku between Broly's thighs for a reason? You tell me. Vincent James may be a good guy, but his discussion was infuriating. Absolutely infuriating. I got nothing against the guy. Just that discussion made me want to claw my eyeballs out. Oh, real quick, while we have a second, I want to say a big shout out to my boy, Marty. I got it. This is Lion L. Johnson. My man Marty was able to secure me a copy of this, and I will be forever humbly grateful. This was released on the 29th of February while I was at Kitchener, and it's only available at Games Workshop stores for their Games Workshop Day or whatever. And so, what? Here it is. Beautiful. I'm looking very much forward to it, to reading it. So thanks, buddy. Very, very awesome. Number 6679. Congrats. It was not 6679. It's number, what is it? Here we go. Just a second, I'll tell you. Oh wait, it's number 447 out of 2,500. Thank you. I've never gotten like a good number. But I think I have all of the Primark books. 13. Yep, I have. That makes all of the Primark special edition books that I have in my collection. And when I open my stupid nerd media channel or whatever, I might talk about some of these special edition books. So I really do appreciate it, though. I don't live anywhere near Games Workshop store, so it's like, oh, it'll be limited release to these. Like, damn it! And that's gonna cost me a fortune on eBay. And then Intimidator 0108 says, hey Nick, Router decided to act up like a POS about halfway through your stream. I think I wasted about 45 to 60 minutes restarting it. Here's another 20 so you can suffer in my temporary misfortune too. Lol. Hashtag Godsmack FML. What, are you listening to Voodoo or something? Voodoo is about 45 minutes long. I like that song, but that's a long song. You'll read all those books live on air. I don't think you can do that, but I would love to. I think that'd be fun, man, but I don't think you can, because that would be a good excuse for me to sit down and just read. If I was reading them live, oh God. If only I wouldn't get just absolutely hammered on copyright. Maybe I should do that on BitChute or whatever. Just kidding. All right, guys. Maybe you just have to add your own personal commentary while you read the books. Yeah, that would be a possibility. Just make it significantly transformative. So, we'll see. Read them live in Lemoyne's voice. And he took out his chain sword, and then he shoved it in the Chaos Marine's anus. Oh God, I'd love it if someone would shove something in my anus. All right. Okay, guys, thanks for hanging out with me tonight. I appreciate it as always. Oh, wait, Kay says, I had to watch some online training videos on corporate ethics. I recognize the guy who was narrating it, DC Douglas. Albert Wesker informing me about the corporate ethics is some sweet irony. Oh, God, I'm so sorry. So sorry. All right, guys, come hang out with me on Twitch in just a few minutes. I'm going to go put on the old thought top, grab a snack and a beverage of some sort that is not liquor, and we'll be failing at Sekiro. Keyboard and mouse squad, rise up. We do not capitulate to controller cucks on this Twitch channel. We don't do it. We only keyboard and mouse. Controllers can eat garbage. And then Intimidator 0108 says, nah, Nick, while Voodoo is one of my favorite Godsmack songs, F My Life is another personal favorite of mine. I like to quote when I have a bit of bad luck. Oh, I haven't actually heard that song. So. Will Chercoon have a thought top? We should make that happen. That'd be fun. All right, guys. Thanks for hanging out with me tonight. I will see you over on Twitch. Otherwise, I'll see you tomorrow. Peace. Peace. Blaine 20 says, why can you perform a song for pay but not read a book? It's I don't know. I don't know the answer to that. Maybe I'll consult my copyright attorney and see what they think. All right, guys. Have a good night. Peace.
Born many children as the wife of a lawman. She makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. sweat past